so I'm here to pretty much round off the new laws and regulations segment of your part 3. Jeremy assigned me some very juicy laws here. This has got to be probably the most exciting one. Marijuana, right? Cannabis. You were here last year. We told you and gave you a kind of a warning that this law was enacted last year. It's the off-duty cannabis use and drug results law that was signed in, but it came into effect this year. So back to the future, fast forward, here we are, alarm bells going off. As of January 1st, FEHA was expanded and it now prohibits discrimination for either a person's off-duty cannabis use away from the workplace, right? Off-duty away from workplace, or the more kind of confusing part, the results of an employer-required drug screening test that has found the person to have non-psychoactive cannabis metabolites. So the first part, pretty self-explanatory. Yeah, off-duty, not away from the workplace. But what is this latter part? So we touched upon it briefly last year, but just kind of a refresher. Apparently, when you consume marijuana, you would know, non-psychoactive cannabis metabolites will stay in your system for X amount of time after you consume it. So the employee may have consumed marijuana, weeks beforehand, takes the drug test, and yet this non-psychoactive cannabis metabolites, I'm going to say it 10 times for you, will still stay in their system. And so the employee will test positive for it. Does that mean that they are impaired during work time? No, it just means they've now tested positive for this. Does that mean that, what are employers going to do? We're just going to allow employees wander in impaired under the influence of cannabis? No, we're still frowning upon that. California is protecting marijuana use, but not to that extent. So you can still refuse to hire applicants. You can still screen for marijuana and drug tests, but not if the drug test for non-psychoactive cannabis metabolites. What does that mean? Does that mean we have the science and we have the drug tests that is really going to let us test for psychoactive cannabis metabolites? Not necessarily, right? Because that would just be too easy. So I guess science is still kind of catching up to that. It's a little hard to find, but there are impairment tests that we could be using. And of course, with every good law, there are exceptions, building, construction trades, or federal background investigation, security clearance, because, those are self-explanatory. So then again, this year, California said, let's go ahead and expand PHET even more and really protect marijuana use. Okay, so now we have SB 700. And now California is saying, well, it's also going to be unlawful for the employer to request information from an applicant for employment relating to the prior use of cannabis. Okay, that also includes an employer considering information about prior cannabis use obtained from a criminal history and background check. Of course, there's always got to be an exception, or at least we hope so. So here it is, if it's specifically permitted by the Fair Chance Act or our lovely catch-all, other state or federal laws. All right, that was kind of my juiciest law, so I hope you enjoyed it. Here and after, we have one more California law, and then I'm going to quickly run through some New York laws for you all. For my New York employers, for my non-New York employers, bear with me, I'll try to entertain you regardless. So we have retaliation of rebuttable presumption. Okay, SB 497. What this pretty much does is says, we're going to make it harder for California employers. But that's been the theme of the talk, right? As we know, well, for those of us who speak legalese, California retaliation cases have a burden shifting framework, right? So the employee has to establish a prima facie case. The burden then shifts to the employer to say, no, there was a legitimate business reason for my conduct. It was not retaliation. And the burden shifts back to the employee, and the employee says, no, it was pretext, XYZ reasons, here it is. Okay, so for that first portion, for that prima facie part that the employee has to establish, the employee typically has to say, well, I engaged in protected conduct, okay? And here it is limited and very specific to those within the California Labor Code and the California Employment or Equal Pay Act, So for example, let's say an employee reports to an employment agency and says, I have a reasonable belief that the employer is requiring me to do something that I believe violates the law. Okay, that would be their protected conduct here. The employee would have to do the protected conduct. Then they have to show that the employer did adversely, right? You reprimanded them, maybe for being tardy. And then they have to show that causal connection between the two. All of those beautiful factors to show their prima facie case, right? Well, California said, well, we're going to make it easier for the employee because we like to do that from time to time. And we're just going to presume, right? We're just going to presume that if the employer acts adversely within 90 days of the employee having acted accordingly, then then there's retaliation. So that's another fun stuff. But in addition to that, we're going to give employees more incentive, right? So before, the law allowed for $10,000 in civil penalties, up to discretion of the labor commissioner. But there wasn't explicit that that was going directly to the employee. Now California is like, well, let's give each employee up to $10,000. We'll see how that goes. Okay, I'm here to catch us up. So New York laws, just 4 laws. We're gonna go down dirty here. Minimum wage increases, right, every year. New York State, $15. City is $16 an hour. And then New York has implemented a prohibition of access to employee social media accounts. This should ring a bell for my California employers because this happened, I want to say like in 2013, possibly 2016, difficult right now. But effective March 12th of this year, New York employers are prohibited from requiring employees or applicants to provide access to social media accounts. So does that mean that you can't log on to Instagram, Facebook, check out your employee's social media account, find out if they're really sick that day? No, right? If it's public, it's public. What it means is you cannot require the employee to give you their login, their password, their account information. Okay, New York City prohibits height and weight discrimination. New York City, not California. Okay, I know this is surprising. Not California, although San Francisco, and I think Santa Clara, but for sure San Francisco have this prohibition as well. New York City has come out and prohibited height and weight discrimination. So we like to give sexual harassment trainings here at MSK. This is part of our list of things to do. And during our sexual harassment trainings, we always like to say, can you guess the one exception to this? What would be the one exception where you can take into account height and weight when making an employment decision? It typically has to do with the entertainment sector. Anyway?
Casting.
Yes, casting, love it. So yeah, you're actors, right? Broadway. So yeah, there's always some exceptions, maybe an athlete, but generally that's the new prohibition, the new discrimination prohibition. And finally, because I told you I'd make this quick and painless, we have limitations on non-disclosure provisions in New York settlement agreements. Now, that's not just settlement agreements, that is severance agreements, separation agreements. This was effective November last year. And most importantly, what it does is that if there is a claim for discrimination, harassment, or retaliation, and the settlement agreement requires or includes a liquidated damages provision for the employee's violation of that non-disclosure provision, then that's not allowed. That's fine. Or if you're requiring the employee to forfeit the consideration that they've obtained by means of executing the settlement agreement or severance agreement, also not allowed. Or obviously an affirmative statement or assertion by the employee that they were not subject to discrimination. So this kind of goes on the tail end of Me Too laws. We don't want to muzzle employees, right? And as promised, that was quick and painless, but we have saved the best for last year.